Hi, my name is Richard Smith, and I'm Privacy Specialist for DCH Health System. The Compliance Department for DCH supports the HIPAA privacy and security rules through auditing and monitoring, education, like what we're doing now, and through investigations of complaints. We want to warn you that the information that we're providing here today is very important. HIPAA privacy and confidentiality is an important topic for all DCH workforce members. You can be fired if you violate the HIPAA privacy regulations and our privacy policies here at DCH. This is very important for you to understand before you begin working with our patients and using their information. If you have questions, please ask somebody. We'll have contact information for you at the end of this session so that you can ask questions as needed. Remember, you are responsible for HIPAA privacy. You receive education through activities like this here, your orientation as a new employee, staff meetings, the DCH Monitor, which is our intranet site, and our compliance and audit intranet page also provides additional information for you throughout the year. Annual computer-based training also provides an update for you once a year. When you sign on at DCH, you sign your confidentiality agreement, and as part of that, you acknowledge your responsibility for HIPAA. And you also do this every year when you re-sign that document as part of your evaluation. So what is HIPAA? HIPAA is the Health Insurance Portability and Accountability Act of 1996. We don't expect people to remember all of that, but the most important part of HIPAA for you to remember is that the privacy rules are a part of HIPAA, and they establish how we can use our patients' information, how we can share it, and what we can do with it. These became effective in 2003 and have been modified over the years, most recently by the HIPAA Omnibus Final Rule that was issued in January of 2013. The purpose of the privacy rules is to guide how we use our patients' information, how we protect it, and how we share it. It establishes when and under what circumstances that information can be shared, how we inform our patients about our privacy practices, and how an individual can use PHI. You'll hear us talk about PHI, and you want to know what it is. Well, it's protected health information. It is any information that is individually identifiable regarding our patients, and it can be in any medium, and it can either clearly identify the patient, or it can be information that can be reasonably assumed to identify the patient. When we look at the examples of identifiers that are included in PHI, there's name, address, phone number, social security number, account number, date of birth, photograph, email addresses, insurance information, genetic information, even your vehicle tag number can be included as one of those identifiers. It's very important to protect these identifiers and the medical information that goes with them. Insurance information, for instance, is part of a very lucrative form of identity theft. A recent Ponemon Institute study showed that the average cost to a patient for medical identity theft is over $21,000. The HIPAA privacy rule provides for patient rights. Each of our patients, upon their first visit, receives what's known as the Notice of Privacy Practices. This is about a 5-page document that describes how we're going to use our patients' information, what protections we're going to provide, what rights they have, and how they can complain if they feel that those rights have been violated. Each of our patients has a right to request a restriction on their information. For instance, a spouse may not want the other spouse to know why they're here for an elective surgery. We don't get to judge why someone wants a restriction, whether it's a worthwhile restriction. We only can consider whether or not we can reasonably accommodate that restriction. Patients can also request that we communicate in an alternative form, such as only send information to my P.O. box, only call me on my cell phone, don't leave voicemail messages at my house. All of these are rights of our patients. Patients also have a right to access and receive a copy of their medical records, and this is regardless of whether or not they have an outstanding bill or anything like that. Patients also have a right to an accounting of disclosures, which means that we have to track who and when we send out information on our patients. And finally, patients have a right to request an amendment if they feel that their record is inaccurate or incomplete. DCH has established privacy policies to support our compliance with the privacy rules. These policies provide guidance on how to use, protect, and disclose PHI. They also establish policies for auditing, investigating, and discipline related to the privacy compliance. This is very important for you to understand. All of our policies are available on the intranet and are there for your review. They're there for your information. We want you to understand our policies, and so anytime you have questions about them, ask us. We update these policies as necessary based on changes in laws and regulations, and we want to make sure that at all times we're providing the highest level of protection for our patients' information. Another policy for you to be aware of is the cell phone use policy here at DCH. Employees are prohibited from using cameras built into portable electronic devices such as cell phones and other electronic devices capable of storing and transmitting images. What this means is that we don't use our cell phones to take pictures while we're at work. There's a cell phone use policy that's listed under the HR portion of the intranet. We want you to read and understand that. Now, the reason for not using our cell phone cameras while we're at work is how easy it is for us to take a picture and not realize that in the background there might be a patient, there might be a computer screen with patient information, or even printed information lying on counters. We have encountered employees who have taken pictures and posted those pictures to Facebook, and when you zoom in on the pictures, you can in fact make out what is written on pieces of paper lying on their desk. So in order to help prevent inadvertent disclosures of PHI through taking pictures and making those publicly available, we emphasize that the DCH policy is that we do not use our cell phone cameras at work. There are limited situations such as departmental functions, maybe in a break room, where a manager can approve that, but we always want you to use caution. Even if it is an approved use, make sure that you know what's in the room and that you ensure that there's no PHI that could possibly be in that picture. But again, in general, our policy is do not take pictures at work. The privacy rules permit us to make certain disclosures and uses of information as part of doing our jobs. PHI can be released without prior authorization for treatment, payment, and healthcare operations. Most of us live in the treatment realm. We take care of patients. But there are others of us who deal with payments such as insurance and coordinating with collections agencies, things like that, and healthcare operations such as patient safety, hospital administration. All of these things do not require a written authorization from the patient. The laws say that this is part of taking care of the patients. It's part of doing our jobs. But as a general rule, anything beyond treatment, payment, and healthcare operations will require a written authorization from the patient. We want you to understand that a written authorization is different than just verbal permission. This is a specific form, and this has requirements that are outlined by the law. Treatment, payment, and healthcare operations, again, is part of taking care of the patient. We use our patients' information every day in what we do to care for our patients and run the hospital. We can also communicate with other healthcare providers. We can coordinate with other doctors' offices, other healthcare facilities. We might have to release information to insurance plans to receive payment or to government agencies. But in general, if what you're using or disclosing patient information for is not part of your job function, then it's a potential policy violation and also a potential violation of the HIPAA privacy rules. The need to know minimum necessary standard applies to all of our access, use, and disclosures of information. Only employees with a need to know to do their jobs may access a patient's information. HIPAA also requires us to disclose only the minimum amount necessary to other people to do their jobs. Before you disclose information, ask yourself, do I need to know this information to do my job and provide quality care for this patient? And what is the minimum amount of information that is necessary for taking care of this patient? Why does the need to know minimum necessary standard mean so much to us as employees? Because DCH policy prohibits employees from accessing their own medical record, their family members' medical records, their co-workers' medical record, or any medical record for any person for whom the employee isn't providing care. Basically, do not access a patient's medical record unless it's part of doing your job. And one of the reasons that this is so important for you to understand is that DCH conducts daily audits. I have software that allows me to run reports that show me when somebody is potentially accessing a patient for whom they don't have a job purpose. Now, this might be looking at the same last name or people with similar addresses, guarantor subscriber name matches from insurance information, or looking at one employee looking at another. Improper access can lead to discipline up to and including termination. And I want to give you a few examples on the next slide. In the past years here at DCH, we had a random audit that revealed an employee snooping in emergency department records. This employee stated that they were bored, they were curious, and we didn't have a reason to audit this person, but a random audit showed that this access had taken place. Upon further investigation, the employee said that she didn't know the young man for whom she was reading his records. She simply opened his record out of curiosity and began to read it. This young man had been shot and died from his wounds, so he had been violently murdered, and our employee violated his HIPAA rights by treating his information as her own entertainment. So the random audit revealed this. Other for-cause audits that we run, such as the last name, address matches, things like that, have revealed employees looking up lab results for family members. This is a violation of DCH policy because we have specific release of information procedures that should be followed. If someone in your family needs information, they have access to that information through their physician requesting it, or they can request it directly from medical records release of information. Also, a high-profile audit. I want you to understand that anytime that we become aware of a patient in the news, maybe on Facebook, in the community, prayer requests at church, or employee complaints, different things like that, people will say, we want you to be sure that nobody accesses this record who shouldn't. We'll run high-profile audits on those individuals, and we'll look at all the employees who access that record. And we have, unfortunately, found our employees snooping in records for whom they had no business reason accessing these things. And we have actually had people who have lost their jobs because of accessing high-profile patients, somebody they were just curious about, and we're not involved in any way in the care and treatment of the patient. So these high-profile audits can reveal that. So we want you to use caution in which patients you access. Always have a reason to go into that patient. If you don't have a business reason for accessing a patient, don't do it. One of the problems with accessing patients without reason is that it could actually be a breach. So what is a breach? A breach is the acquisition, access, use, or disclosure of protected health information in a manner that is not permitted under the privacy rules. When somebody accesses a patient without reason, when somebody accidentally discloses or even intentionally discloses information in violation of the privacy rules, then that's a breach, and it's a very serious thing. The HIPAA Omnibus Rule that was released in January of 2013 requires that we notify our patients when a breach occurs. The hospital is required to help mitigate the harm, which means we help clean up the mess, basically, that if there's any financial loss to the patient, we deal with that. We help secure information that has been inappropriately released. But then we have to report that breach to the patient. Now, we send the patient a letter in the mail within 60 days of the discovery of the breach. But we also have to notify the Department of Health and Human Services through the Office of Civil Rights. If that breach involves less than 500 people, at the end of the year, we'll report all of those breaches at one time. But if that breach involves 500 or more people, we have to report that right away to the government. Also, if it involves 500 or more people, we have to notify the news media in the affected areas of these breaches. One of the things that these breach notifications does is it erodes the confidence of the patient in DCH to protect their privacy. Our patients are important to us. And so as patients lose their trust in DCH to protect their privacy, they might choose to go somewhere else for their treatment. As part of that, it begins to affect DCH by eroding our patient base. Our patients don't trust us, they bypass us, they go to other hospitals, and we have less patients, which means we have less income to help support our staff. And so this has a great effect on our patients and our community. So we want to do our best to avoid these breaches. In the year 2013, we recorded nationwide 211 breaches of 500 or more patients. Now, this is all healthcare entities in the U.S. 500 or more patients affected. There were 211 breaches. There were 6,400,000 patients notified that their health information had been breached. Again, these are nationwide numbers. But for here at DCH Health System, we had 14 reportable breaches for 2013, and 91 patients were notified that their health information had been breached. Some of those breaches were inadvertent disclosures by DCH Health System employees. Some of those were by vendors. But in the end, 91 patients got letters from DCH stating that their information had been breached according to the privacy rules. I want to give you some examples of breaches that occurred here at DCH in 2013. The first example was when a local church called us and stated that they had received patient information from DCH. Our investigation revealed that a DCH employee failed to verify a fax number and also failed to use a cover sheet on the fax. And when this fax went out, it ended up going to the local church instead of to the intended recipient. They notified us that this had happened, and we had to notify the patient that his information had been breached. Another breach occurred when an employee failed to verify all of the pages in a printout that was given to a patient at discharge. Now, what had happened was that more than one patient's information had printed to the same printer. By failing to verify the pages of the information belonged to only one patient, several patients' information were released at one time. Another breach occurred when 30 patients' information were sent to the wrong recipients in an email attachment. The employee had a new process and wasn't familiar with the process entirely and accidentally released 30 patients. Now, on these patients, we actually ended up having to provide credit monitoring along with our notification. So there was quite a bit of mitigation expense incurred with this breach. The final example I want to give you is one that was of a 35-year-plus nursing veteran. She had been involved in a patient's care in surgery. After this care had taken place, later on during the weekend, she had gotten a phone call from a friend, and she knew that this friend was the grandmother of this patient. As she was talking about something entirely different, she asked her friend, "Hey, by the way, how's your granddaughter doing?" The friend said, "How did you know about that? Were you part of her care there?" Our employee said, "Yes, I was. I want you to know that she did great, and I think she's going to be just fine. She should heal just fine from the surgery. I don't think there's going to be any issues there." What our employee didn't understand was that this information then began to be used in a family argument. So when we received the complaint was that a DCH employee had shared information with a family member, and that in the community people were saying, "We don't think that you're right in this argument because somebody from DCH told us something different." Our privacy investigation revealed that this was an unauthorized disclosure, and our employee lost her job. But the primary impact of this investigation, the primary problem with it, was the difficulty that it caused the family. This hurt our patient. This hurt our patient's family. This is one of the biggest reasons that we want to do the right thing with privacy. Along with the impact on our patients, there's also other consequences that are possible. HIPAA carries with it civil monetary penalties that DCH Health System can face. These range from a minimum of $100 up to a maximum of $50,000 per incident, and DCH can actually be fined up to $1.5 million per regulation violated per year. These fines are staggered, and they increase based on the reason behind the breach, but each of them carry, again, that maximum monetary penalty of $1.5 million per year. Such a penalty could have a significant financial impact on DCH, and along with that penalty would come the mitigation costs for these breaches. Some of the average mitigation costs approach $15 million for some of these high-level breaches. In addition to civil penalties, HIPAA also carries a criminal penalty when an individual breaches a patient's protected health information intentionally. Now, these penalties can range all the way up to $250,000 in fines and 10 years in jail. Some examples of criminal penalties for HIPAA include a UCLA researcher who was notified of his termination, and upon this notification, he decided that he would access the records of his coworkers and his superiors, along with several celebrities. He was ultimately convicted and sentenced to 4 years in jail. There was an LPN from a medical clinic who accessed and acquired the PHI of a patient to give to her husband. Her husband was actually involved in a legal proceeding against this patient and wanted to use that PHI against the patient. Well, what ended up happening was that the husband and the LPN were both indicted. Ultimately, the LPN pleaded guilty to the charges, and the charges were dropped against her husband. Finally, an example that hits close to home is that at Trinity Medical Center over in Alabama, Birmingham, Alabama, an employee was indicted for stealing identifying information of 4,000 patients for committing identity theft. Along with the criminal and civil penalties that are possible with HIPAA, there's disciplinary guidelines that DCH has established for our employees regarding violations of our privacy policies and procedures. Now, these can include anything from a point of discussion up to termination. An inadvertent disclosure of protected health information, if this is with no prior discipline in the past 12 months, you can receive a point of discussion. This is the lowest level of official discipline that we have at DCH. But unauthorized disclosure of PHI, whether inadvertent or intentional, can result in termination, even on the first offense. So we want you to understand that it is very serious when violations occur, when inappropriate disclosure takes place. So we want you to use great amounts of caution. We're glad to have you as an employee, and we certainly hate to see when a privacy violation costs a good employee their job. When it comes to sharing PHI outside of work, the general rule is don't do it. Do not discuss your job on the internet, over the telephone, or in person if it has anything to do with your patients. We have lots of people in our community that know that we work for DCH. Even after we take the badge off, people still recognize us as DCH employees, and they want to know about their friends and family members for whom we may or may not have been involved in their care. But when people ask us about patients, the best response and the right response is going to be, I'm sorry, I can't discuss my patients outside of work. Even if we don't mention our patients by name, discussing our patients outside of work can still constitute a violation of our policies and of the HIPAA privacy rules. On this slide here, we have a screenshot from Facebook that was submitted to us, and there's a breach taking place here. Now, when we look at this, we see that an employee, it's not actually the employee that's discussing this, it's a family member. What happened was that there had been a young man reported missing in the news, and these two people had been discussing it. The employee was on her way to work, stopped by to talk to her stepmother, and they had discussed this matter. Well, when our employee got to work, she looked up, and this young man came through her station there, and she was part of this young man's care. Well, she called her stepmother and said, you know what? They found him. He's a little bit dirty, but he's okay. Well, the stepmother then took this information that she had received, this unauthorized disclosure of information, and she put it on Facebook. So now, when somebody questioned her, how do you know for sure that this is right? The stepmother backed up her story by saying, well, my stepdaughter who works at DCH saw him. This happens a lot, that people want justification, they want to show that they're right, and they'll say, well, I have it on good authority from someone at DCH. That should never be able to be said. We don't discuss our patients outside of work. And this is a prime example because this is a breach. When our employee shared this information with her stepmother, that was an unauthorized disclosure. Once we have disclosed that information, we cannot control how other people use that information. And as you can see here, the information was posted publicly, and now we have permanent evidence of that. Incidental uses and disclosures of PHI happen as part of taking care of our patients. The privacy rules expect us to use reasonable safeguards as we care for our patients. There's going to be times that we have to call a patient's name in a crowded waiting room, situations like in the emergency room where other people might overhear our conversations while we're talking to patients, semi-private rooms that don't provide absolute privacy for our patients. But we want to use reasonable safeguards. Things such as talking in a low, appropriate tone while we're talking to individuals when there's others in the room. Reasonable steps that we can take to protect our patients. One very important reasonable safeguard that we want to take is that when other people are in the room, we need to ask a patient if they would like privacy. Now, what I'm referring to here is when you have friends and family who might be in a patient's room and you need to share something like medication purposes, planned testing, medical information. Ask people, is this okay if I talk about these things in front of the people that are in the room? We can't always assume that everyone in the room is someone that the patient wants to have their information. A great example of this is that one of our caregivers walked into a patient's room and began discussing this patient's HIV positive status with the patient. In the room with the patient was a family member who did not know and to whom the patient had chosen not to disclose his HIV positive status. So by failing to ask permission to talk about it in front of other people, our caregiver violated this patient's right to restrict that information. We want to ensure that our patients always feel comfortable with us sharing the information with whomever is in the room. So take the time to ask. When you're going to speak to a patient and there's people in the room that you're not familiar with, ask the patient, is this okay? And they'll tell you yes or no. And if they say, I want some privacy, don't be afraid to ask the people that are in the room to leave and give you privacy until you've had a chance to finish talking to the patients. Some things that we can do to enhance the security of PHI is that we don't want to access information that we don't have a need for. We also don't want to make copies that aren't needed, and we want to ensure that when we do make copies that we don't leave the originals on the glass. Don't fax patient health information unless you're certain of the fax number being correct. Remember our example before where somebody failed to verify a fax number and breached the patient's information by sending it to the wrong fax machine. Be very careful about the numbers when you dial them and use pre-programmed fax numbers when possible. Also, don't fax PHI without a completed fax cover sheet. Some things that we can do to protect the security of PHI is to keep records secure when not in use. Put them in a file cabinet, put them in a locked room when they're not in use, put them where they belong, and don't leave them laying around on places like counters and hallways. Challenge people that are in the records area that you don't think belong there. A very disarming way to do this is just to walk up to somebody and say, excuse me, can I help you? And most of the time people will tell you why they're there and what they're looking for. If you have questions about record handling or storage, contact your supervisor. We always want you to ask first when you're not sure, because that's the best way to protect the privacy of our patients. Again, only release the minimum necessary to get the job done, and keep all PHI protected when electronic systems are down. Talk to your manager or supervisor about how your department handles this. Other ways to minimize exposure is that PHI should never be left unattended where others can access or view it. A locked office door does not minimize exposure to those who have keys. So things that are supposed to be put away in cabinets and places like that should always be put away at the end of the day. And something that's very important is that when documents are no longer needed, they must be shredded. We contract with a company called Shred-it that provide us bins that are all over the hospital that we can place any kind of printed PHI in these bins, and they bring a truck here to DCH and actually shred these documents before they ever even leave the campus. This provides a high level of security, and we are assured that these things are properly destroyed. If you dispose of printed PHI in a regular garbage can, it can actually result in termination. It is very important that we always shred documents that are no longer needed. One exception to this is medical waste that has PHI printed on it. Now, this can be disposed of in a red bag. That's an appropriate means of disposal of medical waste that contains PHI. But any other printed PHI needs to be disposed of through the shredded bins or a shredder. Computer access security is very important. Your password is like your fingerprint. When we run our audits, we look and see who accessed the patient and whether or not that individual had a business use for accessing that patient. We've had instances, an example of which would be that an audit showed that an ED employee had accessed her husband's medical record while he was being treated. Now, when we asked the employee, why did you access his record? The employee said, I never did. I would never do that. We showed her the audit log and showed her where the records indicated that her password had been used to access his record. And her response was, well, I don't always log off of my computer, and I have a shared office, so more than likely that's what happened, is that somebody else accessed him using my password because I didn't log out. Well, this resulted in discipline for our employee for failure to safeguard her password. We want you to always lock or log off of your system when you're finished with it, or if you have to leave it. And if you believe that your access has been acquired by someone else, contact IS and they can help you reset that. Do not share your password, and also don't write it down and leave it in places where other people can find it. Remember, if your password is used to access information, you are responsible for what happens with it. Access to patient information is something that people want all the time. In order to accomplish this and to make it convenient for our patients, we provide the MyDCH patient portal. This provides direct access to one's own PHI through the internet without any cost. There's no sign-up fees or any software that has to be downloaded. You simply have to register through medical records, and you can sign up for access to yourself or to receive proxy access for someone else. This helps you have access to this information whenever it's needed, and your friends and family can access their own records as well. We emphasize that you should not use your access for anything other than business reasons, and that includes looking up yourself for friends or family members. This is a convenient way to make sure that you're doing the right thing when it comes to accessing your records. Any access to the MyDCH patient portal is fine, but if you're using your DCH employee access to access the same information, you can face discipline. The Office for Civil Rights investigates privacy and security complaints and enforces the privacy and security rules. We want to do everything we can to ensure that the Office for Civil Rights doesn't have a reason to be here at DCH. We want to do the right thing in the first place, but patients who feel that we've potentially violated their HIPAA rights have a right to complain to the Office for Civil Rights, and they'll contact us, they'll investigate the matter, and if resolution is needed, they'll be the ones who provide that. They take actions to correct problems and resolve complaints. Finally, we don't want you to be a headline. Some of the headlines that we've seen over the past years include employees fired for snooping on the electronic records of college football players, the UCLA employee that I spoke of earlier that was jailed for violating HIPAA privacy rules, a nurse pleading guilty to a HIPAA privacy breach. We also have seen fines in the news. UCLA paid a fine of $865,000. Rite Aid paid a fine of $1 million for HIPAA privacy breaches. Blue Cross Blue Shield of Tennessee lost some backup tapes to their servers that contained PHI and settled out for $1.5 million. And there was even a $4.3 million civil monetary penalty for a violation of the privacy rules. And this was the actual first penalty that was issued. Most of these other cases that have financial penalties involved have been settlements. Recently there was a press release about a disclosure that happened in Puerto Rico that actually incurred a $6.8 million fine. So this can be quite damaging to an institution, but again, we want you to consider the impact to the community, to the patients who are served by these institutions as well. Finally, anytime that you want to ask questions, anytime that you have concerns that you want to share, we want you to feel free to contact our office and discuss these matters with us. You can contact Sheila Limroth, our Corporate Director of Internal Audit and Compliance, at extension 5328. You can contact me, Richard Smith, the Privacy Specialist, at extension 8655. We also provide a toll-free compliance hotline that you can call. The number is listed on our internet webpage as well. You can call this line 24 hours a day. You can even leave a concern anonymously on this line if you want to. Anytime that you have questions, please contact somebody, ask questions ahead of time so that we can protect our patients' privacy. Thank you.